Good morning, ladies and gentlemen. I thank you once again for reporting promptly to the courthouse. Members of the jury, there have been 4 additional exhibits received in evidence as defense exhibits. They are the certified copies of the judgment and sentence regarding each of the 4 co-defendants: Charlie Ely, Justin Soto, Amber Wright, and Kyle Hooper. Each of them are presently serving a life sentence, that is a term of imprisonment for life without the possibility of parole. Members of the jury, both the state and the defense have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but in this penalty phase, the state proceeds first, and then the defense will present their final argument. There is no rebuttal closing argument by the state. Each side will have one final argument. Ms. Byrne?
May it please the court, counsel? Good morning, members of the jury. Michael Bargo is a psychopath. He's a criminally oriented guy who gets an idea in his head and he carries it out. He hated Seth Jackson, he wanted him dead, so he killed him. Could he control his actions and his behaviors on April 17th of 2011? Absolutely. Not only was he in total control of his own actions and behaviors, but he was controlling the actions of 4 other people that night as well. Now you're going to get, again, more jury instructions. This is like the package you got during the guilt phase, but this is for the penalty phase. And it's a smaller package, but it's no less important in this part of the trial. And what the judge is going to read to you, again, is about the aggravators. And he's going to tell you that there are 2 aggravators that you can consider in this case. And those are the 2 aggravators that I talked to you about in the opening statement: cold, calculated, and premeditated, and heinous, atrocious, and cruel. And what the judge is going to tell you, that if you find that we've proven at least one of those to you beyond a reasonable doubt, then you move on and you consider the mitigators that were presented by the defense in this case. And you weigh the mitigators against the aggravators in this case. And that's where the difficulty comes in, is how do you weigh them? There's no instruction on how you weigh the aggravators and the mitigators. It's up to each of you individually to decide how much weight you give an aggravator or a mitigator. There's not a list of factors that say give this one more or this one less. You make that determination individually. And I want to start this morning by talking about the mitigators that the judge is going to read to you, that have been presented by the defendant in this case. And talk about how much weight you should give these mitigators on the scale that you will use to determine whether you should recommend that the defendant, Michael Bargo, be sentenced to death or life in prison. Now, I know it's listed as 5 mitigators, but before we go through those, understand that number 5 itself could contain 50 mitigators within that number, because that's any factor that they have presented about his background, character, or life. So just with that understanding, I'm going to read through these. The number 5 may contain a lot more mitigators, and they'll talk about that when they do their closing. The first mitigator the judge is going to read to you is this: the capital felony was committed while he was under the influence of extreme or emotional disturbance. And these are all in the jury instructions, the package that you're going to get to take back with you. I just put them up there so we can discuss them. And this is obviously going to go to his mental health, and you've heard a lot of evidence about that. Number 2, the defendant acted under extreme duress or under the substantial domination of another person. 3, the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. The age of the defendant at the time of the crime. And number 5, the existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense. Now I want to start by talking about number 2 and go through and discuss with you how much weight, number 1, have these been proven by a greater weight of the evidence. That is their standard. It's not a beyond a reasonable doubt, which is what the state has to prove. Theirs is a greater weight of the evidence. Has the mitigator been proven by a greater weight of the evidence? If so, how much weight should you give it? So let's look at number 2 first. The defendant acted under extreme duress or under the substantial domination of another person. Now I know friends and family that have testified all considered the defendant a follower when he was younger, and that's how they described him. But clearly, he was the leader of all the people at Charlie Ely's house. He was in charge, and he ran the show there. He testified that Charlie Ely wanted him to move in, and he agreed, but it would be on his terms. That's what he said when he sat here and testified. He testified over and over again how he tried to help Kyle do the right thing. He told Kyle, get up, you have to go to work. Don't fight with Alyssa Masters. He said he had to hit him with tough love. The defendant made the plan. He assigned the roles. He decided how, where, and when to dispose of Seth's body. He called his dad while Seth's body was burning in the fire pit. Why? Because he wanted a cigarette. And his dad described him as acting normal. Is that somebody under extreme duress or under the substantial domination of another person? Was somebody else making him do these things? Was he under extreme duress? I would submit to you that this was not proven by a greater weight of the evidence. And that as to this mitigator, you should give this little or no weight at all. Next is the age. The age of the defendant at the time of the crime. We talked a lot about this in jury selection. The defendant turned 19 12 days after he shot and killed Seth Jackson. Does the fact that on April 17th of 2011, Michael Bargo was 18 years old, does that fact reduce the degree of his criminal responsibility for the murder of Seth Jackson? Young people do dumb things. They drive their cars too fast. They stay out late. They fight over girls. They may even get in a physical altercation and beat up another guy over a girl. Those are dumb kid decisions. What he did is not a dumb kid decision. That's the difference when you look at the age. Seth Jackson isn't dead because he made a dumb kid decision. Seth is dead because the defendant wanted him dead. And whether he was 18 or not, he carefully plotted and planned and carried out his death. And I submit to you that you do not give that mitigator much weight at all. When you put that on the scale, how much is that scale going to move? None to very little. The existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense. We've heard quite a bit of testimony and evidence about this over the last couple days. What do we know about the defendant's character and his background? Well, we know that when he was younger, he was described by the neighbors that lived next door to him for years. Their family is a great family, a normal family, that his mother and father were caring and loving. And they never saw those parents abuse him in any way. They went camping, they went fishing. He played Little League, and he played basketball. His mother described him as spoiled. I said, would you describe him as a spoiled child? Yes. In 3rd grade, he was diagnosed with ADHD and ADD. And Dr. Pritchard said, that's a behavioral thing. It's a hyperactive kid. We've heard a lot of testimony about that. Your kid is hyperactive. 5.2 million children in the United States are diagnosed with that. So he was hyperactive in 3rd grade, and he got put on some medication. And then his defendants went through a bitter divorce when he was about 12 years old. There's no disputing that. The parents obviously hate each other, and it was a bitter divorce, no question. 40 to 50% of marriages end in divorce. The defendant wanted to live with his dad, and he blamed his mom for the divorce. He was angry. But he made the decision to start breaking the rules and breaking the law. He made that decision because he had choices. He was sent to several psychologists and tried to help him. You're going to get to look at a book of pictures you haven't seen. This is the defense put this book in. You're going to see these. I'm sure they're going to put them up all over the courtroom. This is the defendant when he was younger. Again, with his dog that we've heard about, his great life. And that's what these pictures are. Great. His parents got divorced. He had a hard time with it. It was a bad divorce. What did they do? Tried to help him. Let's send him to a counselor. We try to get him help. We send him to one, we send him to another. But he made the choice of which way to go. Did he want to turn his life around at this point and get better and get help and get over the divorce? Or did he want to become angry and oppositional and defiant and negativistic? That's what he chose. It was his choice. And the question is, how much weight do you give to the character of this man who made those choices against the gravity of this crime? How much weight do you give to the character of this man? And I submit to you, no or little weight do any of these things get when you get to that scale. Now, when you put that on there, it's not going to move. And we get down basically to the crux of the other mitigators and what a lot of the testimony has been about. What's wrong with him? Let's talk about the defendant's mental health. Is it some kind of psychosis, or is it just bad behavior? There is, I submit to you, no evidence that the defendant was suffering from any signs of a psychosis or a seizure of the brain on April 17th of 2011, when Seth was killed, or April 18th of 2011, when he was still carrying out the plan and disposing of the body. He wasn't hallucinating, he wasn't delusional, and he clearly was not disorganized in his thinking. He was not in the middle of a psychotic break. He orchestrated the crime, and he had a number of players underneath him. He had a motive. He hated Seth. The plotting and the execution of this plan lasted over a period of 2 days. I mean, this is talking about it, planning it, setting a fire, murder, torture, disposing of the body. That was not anybody who's in the middle of a psychotic break. This is what he has. Oppositional, defiant behavior disorder. It's a behavior disorder that he can control. And you're not going to have to just take the word of Dr. Pritchard, who was our witness, because you have plenty of evidence that he's had that since he made the decision to act out and not turn his life around when he could have. And you're going to get all these records. The records, the testimony of witnesses, and the reports from several psychologists support Dr. Pritchard's testimony. The defendant started seeing a psychologist named Dr. Farmer when he was 14. And you're going to get, these are the records from Dr. Farmer. You can read these, they have all of his notes. He sees Dr. Farmer twice a week for 1 year, one-on-one session, twice a week. So clearly Dr. Farmer gets to know the defendant. And in these records, Dr. Farmer had a heading contents of the session, what the session was about. And these are some things from the contents of the sessions that at 14 Dr. Farmer had with the defendant. And the ones that are in quotes are taken directly from these records. You can read them yourself. Bad-mouthing his mother. Once again, blaming her for all that is wrong in his life. Acting out in all respects so he can go live with his father. Accepting no responsibility or accountability for his emotional stability. Thinking he can act out to get what he wants. Each session note starts out with a section that says presenting symptoms. When the defendant first starts seeing Dr. Farmer, the presenting symptoms start out with depression. But as he continues to see him twice a week for a year, the presenting symptoms are oppositional, defiant, negativistic, and hostile. Exactly what Dr. Pritchett said. None of these notes say anything about psychosis, seizures of the brain, or hallucinations. He goes to see another psychologist. And he was 15. He was 14 when he saw Dr. Farmer, and now he's court-ordered when he's 15. And these records are called the Clinic for Child Study Records. This is where this information comes from. He's seen another doctor, a different doctor. This doctor finds that the defendant's behavior meets the criteria for oppositional defiant behavior disorder. Another completely separate and distinct psychologist says oppositional defiant disorder. And this is what he says about the defendant. The same thing. Michael continues to externalize blame onto others for his problems, rather than seeing responsibility and, very importantly, control lying within himself. He had the control within himself. This is a doctor at 15 that is saying this about him. Personality tests suggest that Michael tends to perceive the world in a self-centered manner. He gets that idea in his head, and he's going to do it. He's going to do what he wants to do. There is no evidence of perceptual disturbance or psychotic symptoms, i.e. hallucinations, and Michael denies any such experience. That is an exact quote from the psychologist in this book. This is 3 years before the murder. This is the same diagnosis as Dr. Pritchett. Now think about that. You have 2 psychologists years before the murder. These psychologists aren't paid by the state, and they're not paid by the defense. This case hadn't even happened when they made these diagnoses. But those 2 psychologists' diagnoses are in complete agreement with what Dr. Pritchett says. And he went through that book called the DSM, and he called it the Psychiatrist Psychologist Bible, that he said they all look at and they all use. And he ran down a list of what is oppositional defiant disorder. It was from that book. And this is the descriptions of what someone who has oppositional defiance disorder acts like. They lose their temper, they're easily annoyed, angry and resentful, argumentative. They argue with authority figures. They actively defy or refuse to comply with requests from authority figures or with rules. And he's told you himself how much he hates the police. He wants nothing to do with them. He's never going to do what they say. Often deliberately annoys others, often blames others for his or her mistakes or behavior. Does that sound familiar? How many of those are familiar? How many times have we heard probably all of those words used to describe Michael Bargo? When you go back, you get to look at all these things the defense has put in. These are all records pertaining to Michael Bargo. You have letters from principals, school records, psychologists, court-ordered people. And I guarantee you, in every one of these books, those words are used to describe Michael Bargo. Like every person that he comes in contact with. That's how they describe him. Because he has oppositional defiant disorder. A behavior disorder that he can control. He made decisions, he made choices to break the rules and break the laws. And he is absolutely able to conform his behavior to the confines of the law. And the last two mitigators are, again, they go to his mental health. And this one is the capital felony was committed while he was under the influence of extreme mental or emotional distress. Was he? If he was, it certainly wasn't severe enough to interfere with his careful planning of sex murder. It didn't stop him from assigning the roles, and it didn't even get in his way when the plan didn't go like it was supposed to. And if you remember when Kyle Hooper testified, he said he started to change his mind. And they were in the bedroom, and he said, I don't think I can go through with it. I don't think I can do it. And he had enough thought and was so well organized and intending for this plan to go through that he had to talk Kyle into it. He told Kyle, come on, man, think of all the stuff he's done to you. He slept with your girl. That's what he did when the plan didn't go as it was supposed to. Is that somebody who's in the middle of a psychotic break or having a seizure of the brain? No. And again, defendant's own father describes him as normal when he sees him. Normal. How much weight do you give to this on the scale, when you put that on the scale? Is the scale going to move? I submit to you now. That scale's not going to move when you put that mitigator on there. And the last mitigator, capacity of the defendant to appreciate the criminality of his conduct, to conform his conduct to the requirements of law was substantially impaired. I submit to you it wasn't. He asked Tracy Wright the next day, would you still love me if I did something bad? He knew what he did. He understood the criminality of his conduct. He fled. Why do you flee? Why do you run and hide at Stark? Because you know what you did. He clearly understood what he was doing. He could conform his conduct to the requirements of the law. He just didn't want to. And as he grew older, that's what he did. He did what he wanted to do. And that's what all of his witnesses said. Faith Christensen, his neighbor, said he wanted to do what he wanted to do. Sarah Jordan, one of his best friends, said he wanted to live with his dad so he could do more of what he liked to do rather than what he should be doing. And Mark Doolin, who was his mother's fiance, said he wanted to stay out later and go places that she didn't want him to go. The defendant himself testified he moved out of his grandmother's house so he could do his own thing. That's what he does. And those were the mitigators. So you have to decide, did any of those mitigators tip the scale? I submit to you no. None of those aggravators tip in this scale at all. And you're going to get an instruction on relative culpability. And I just wanted to touch on that briefly. As the judge told you, you are going to have the certified convictions of the co-defendants in this case. If you find that there was more than one co-defendant, which there was, and Michael Bargo did not act alone, you should consider the relative culpability of each co-defendant. If you find they were equally culpable in the death of Seth Jackson, then he should be treated alike in sentencing and receive equal punishment. If they were equally culpable. There was 5 of them charged, but the difference is there was one person of those 5 that actually took Seth's life and killed him. Only one, and that is the defendant. They are all not equally culpable. The other four, the four that participated and helped under his direction, have been sentenced. They are all serving life in prison without the possibility of parole for their role. They are not equally culpable. He is the one that took Seth's life. And that's why he is being treated differently in this case. Now we have our two aggravators. How much is the scale going to move now? Because it hasn't moved much before with the mitigators. The first aggravator is cold, calculated, and premeditated without any pretense of moral or legal justification. What does that mean? What does cold mean? It means the murder was the product of calm and cool reflection. Calculated means the defendant had a careful plan or prearranged design to commit the murder. For this aggravating circumstance to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. Do we have that here? Did more than just a minute or two pass from the time he said, I want to kill Seth Jackson, and then he killed him? Yes. You have hours. Hours. The evidence is clearly established. He formulated in meticulous detail the plan to kill Seth. And I know you've heard all this before, and this was all, I submit to you, proven beyond a reasonable doubt in the guilt phase. He gave everybody a specific role to play in the murder. Justin was to hit Seth with a piece of wood or an axe handle. Amber and Charlie, you guys lure Seth to the house. The defendant and Kyle will hide in the bedroom. Once Justin hits Seth, Kyle and the defendant would run out of the room, jump on Seth, and beat him up, and then the defendant would shoot him. Those are the specific details that he used to plan this murder. But not only that, it wasn't just the murder. He carefully planned what he's going to do after the murder. We're going to put him in a sleeping bag. We're going to burn his body in a fire pit. He hid the gun in the air conditioning duct. They almost didn't find it. That was that long tube. They had to cut in there to get it. He pulled his teeth out, one by one. He put the body in 5-gallon buckets, and he dumped the buckets in a lime rock pit with the hope that no one will ever find them. Is that cold, calculated, and premeditated? I think that's proven beyond a reasonable doubt. He planned his escape. And if you remember, he called Kristen on Sunday to ask her for gas money, because he knew he was going to have to get out of town. And he didn't have any gas money, because we know he had to go to Kyle's work on Monday to get money from him for gas. So he's even planning his escape that Sunday when he calls Kristen for the gas money. And he confessed to Crystal Anderson that he shot Seth 8 times. We haven't really talked about that, but that in itself requires the defendant to reload that firearm. How premeditated is that? He runs through every round, and he's going to have to reload it. And finally, the second aggravator. As to the first, I submit to you, we're at that scale. That scale's moving. That weighs a lot. Cold, calculated, and premeditated. And now we've got especially heinous, atrocious, or cruel. What does that mean? What is that about? Heinous means extremely wicked or shockingly evil. I don't think anybody can say the details of this crime are not shockingly evil. Atrocious, outrageously wicked and vile. Cruel, designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as heinous, atrocious, or cruel is one accompanied by additional acts that show the crime was conscienceless or pitiless and was unnecessarily torturous to the victim. Unnecessarily torturous to the victim. This is directed at what the victim, Seth, was forced to endure. The defendant wanted Seth to know who it was that killed him. Seth had already been shot multiple times, outside the house and inside the house, when he was put in the bathtub to be tortured by the defendant. And Kyle Hooper testified that Seth woke up in that bathtub. He woke up in that bathtub. And the defendant shot him again. And Kyle Hooper also testified that they tied him up and the defendant tried to break his kneecaps. How much pain was Seth in? And this is what this goes to. How much pain was he in? How much physical pain was he in? He was beaten when he first arrived at the house with a board worn out candle. Beaten right when he walked in. And he was shot several times in the house. But he somehow managed to escape. He got out of that house and ran for his life. But they caught him. He was beaten some more in the yard. Beaten more in the yard. Then he was shot in the yard. Carried inside the house. And then shot again. He was put in the bathtub. Beaten. And if you remember, Kyle said he had to go in there and tell the defendant to stop. Because he kept yelling and beating Seth while he was in the bathtub. The co-defendant had to go in there and tell him to stop. And the cause of death was gunshot wounds and blunt force trauma. That's how Seth died. He suffered physical pain. No question about that. A lot of physical pain. But heinous also refers to another kind of pain. The mental pain of knowing you're about to die. Seth knew he was going to die that night at Charlie's house. And that's why he tried to escape. How do you weigh the magnitude of that kind of suffering? That kind of mental pain? And this went on for a while. During the beating and the shooting, he knew he was going to die. How much weight does that get on that scale? That gets a lot of weight. Cruel. How cruel is this? Again, the defendant didn't just plan to shoot him once he arrived at the house. He had much bigger plans. He wanted Seth alive in that bathtub. So when Seth took his last breath, the last thing he would see is the defendant standing over him just feet away, shooting him in the face. That was part of his plan. And that is cruel. It's cruel by any definition and beyond any reasonable doubt. Now, any jury recommendation, anything a jury recommends that's based on facts and the law, without prejudice, sympathy, or bias, is justice in this country. Justice in this case is a recommendation that the defendant, Michael Bargo, be sentenced to death. Thank you.
Members of the jury, we're going to take a brief recess. We'll reconvene in the courtroom at 5 minutes before 10. You may retire with the bailiff.